Hello, my name is Jennifer, and I am most likely addicted to true crime. Hello, my name is Jennifer, and I am most likely addicted to true crime. Hello, my name is Jennifer. Welcome to it. So many of you will remember that Letecia Stauch was sent to prison in May of 2023 after faking dissociative identity disorder as an excuse to go to a mental institution rather than prison. It didn't work out for her. And now Letecia Stauch wants a new trial. Letecia Stauch has wanted a lot of things over the last 6 years, to include at one point a new face or a full face replacement, I think it was. I don't know. Anyway, my point is Letecia rarely gets what she wants, and there is very good reason for that. This woman has been plotting her appeal since before her conviction, much in the same way that she was plotting her criminal defense before she was even arrested. You know, when she was faking polygraphs and talking about how the jury wouldn't even be able to hear the information about the polygraph. You know, she's already imagining a jury and she hasn't even been arrested yet. And I can almost assure you that she's done the same thing with her appeal. She's been thinking about her appeal, in my opinion, since before she was arrested. Anyway, so before we get started, you know, like I said, I wanted to take us back to May of 2023. And May of 2023 is when Letecia Stauch was convicted of Gannon's murder.
I never in my wildest dreams would have ever thought you'd be in danger, buddy, or I wouldn't have not left you. At home with what turned out to be your murderer and the last person to ever see you on this earth.
But you underestimated me. I am Landon, Gannon's mom, and that will never change.
Once I was 7 years old, my mama told me, go make yourself some friends or you'll be lonely.
So in that car ride, I remember it like it was yesterday.
Oh, that's hard to watch. So we just finished a live stream about an hour ago where we reviewed Nicole Fierro's coverage as a reporter for Fox 31. We reviewed her coverage of the Stauch case from beginning, from when Gannon went missing until Letecia was convicted. And after Letecia was convicted, she interviewed Gannon's father and Gannon's mother. And we talked about how Nicole Fierro, at the beginning of this case, before it even became a case, before she was arrested, Letecia tried to drag this reporter in to her narrative back when she was trying to claim that Gannon had been abducted by someone named Quincy Brown, who was on some sort of SO registry. And so Letecia pulled Nicole Fierro in and preyed upon Nicole's desire to get the word out about a missing 11-year-old little boy. And, obviously Nicole is only one of many people that Letecia Stauch has preyed upon. And for the record, continues to prey upon to this day, because this woman is a monster and she just won't stop, Anyway, we just finished this live stream and we went over some of Nicole's initial reporting where she bit the bait, she bit the hook when Letecia was wanting Fox 31 to report that she was a good person. And even the babysitter thinks she's innocent, Anyway, that video's there if you haven't seen it and want to go back and check it out. Like I said, it was just about 2 hours ago. Anyway, so that brings us to now, and now, now is January 31st of 2026, which is exactly 6 years to the day after Letecia did the KKTV interview with her back to the camera. And earlier this week in 2026, the Colorado Court of Appeals heard 15 minutes of oral argument from Letecia Stauch's appellate attorney. And she's arguing 3 points that she believes should get her another trial. As if, right? I mean, what's going to happen in a new trial? Would she try a completely different defense and just try to pretend that something she didn't happen? I mean, she thinks that she's really good at that. She thinks that she can do whatever she wants and then rewrite the story. Oh, God. Anyway, where was I? Oh, Nicole's latest story. How about we just start there? I did clip Fox 31's most recent video about the appeal.
The Colorado Springs stepmother convicted and sentenced to life without parole for killing her stepson Gannon is appealing her conviction.
Letecia Stauch's case went before 3 judges today. Fox 31's Nicole Fierro's on it.
11-year-old Gannon Stauch disappeared exactly 6 years ago today. A jury convicted his stepmom, Letecia Stauch, 3 years later in May of 2023, and a judge sentenced her to life without the possibility of parole. Today, an attorney representing Letecia Stauch in the Colorado Court of Appeals used his 15 minutes on the courtroom floor to argue the first of these 3, quote, issues they submitted as reasons why Stauch's conviction should be reversed. They say a juror connected to her trial had a son-in-law who worked for District Attorney Michael Allen's office. Allen was the lead prosecutor in this case. They argue Stauch's team challenged the juror's family ties during jury selection, but the judge didn't get rid of the juror, and they believe that was wrong. The senior assistant attorney general told the court she doesn't think the trial judge even made an official ruling on the challenge, and she argued Stauch's team didn't follow up properly if they had a concern about this relationship during the jury selection process. The Court of Appeals judges will review a series of past Colorado cases that shape the current laws. We reached out to the district attorney's office over her trial for comment. They sent us a statement, and we have that on our website. Reporting live here in Denver, Nicole Fierro, Fox 31.
And on the screen is an image of Nicole Fierro from back when she was covering the case in real time. And the way that Letecia Stauch tried to drag this woman into her narrative, which she did to many people, but the way she tried to drag this woman into her narrative, and then Letecia tried to take over Nicole's voice and platform as a reporter, because Letecia Stauch was performing and acting out a public relations campaign of her own. And it is truly disgusting. I would like to hear, I would love it if Nicole Fierro or Fox 31 would put together like a feature-length story about the story, from his disappearance all the way to this damn appeal, which I can't imagine would ever fly. So let's take a look, if I can find it here, at the main issues that Nicole Fierro talked about. Okay. So the first issue, and for the record, I do not yet have all of the briefs that were written in favor or against Letecia's appeal yet. I'm still working on it, but there are still motions being written, or I'm sorry, not motions, but they're still being written. So what I'm going to do is, after I receive all of those briefs, then I will just do a recording with no commentary whatsoever, where I read the documents from beginning to end. And then we can really look into Letecia's arguments. I mean, we've seen over the years her civil lawsuit against the El Paso County Criminal Justice Center, and her civil lawsuit against the Topeka Correctional Facility in Kansas, and who even knows who she's going to sue next? Maybe me, if I play my cards right. Bring it on. So anyway, number one, these are the three issues that came forward. Like I said, Letecia's been planning this appeal for a very long time. And we have heard in jail calls where Letecia is conspiring with various fangirls and things of that sort, with how she's going to file a lawsuit against Judge Gregory Werner because of something that she claims he did wrong during the trial. But I don't see any misbehavior by the judge in her actual appellate arguments. She said, I wondered if she would claim, what's the one about ineffectiveness of counsel. We don't see that here. These are the three that finally went to appeal 3 years after her conviction. So number one, the trial court's erroneous denial of a statutorily required challenge for cause of a juror who ultimately served on the jury is structural error requiring reversal. That's a mouthful. So what I did yesterday, and it was tons of fun, the jury selection process was live streamed with permission to record and restream or reproduce, but it was audio only. And so I went back and I reviewed, there were 3 full 6-hour days of jury selection. Hundreds of people went through for jury selection. And we have access to now review the audio of the entire jury selection. So it was 3 full days plus a half a day on the final day to bring together the eventual 12-person jury along with 6 alternates. So there were 18 people technically on the jury, and the juror in question in Letecia's quote-unquote issue number 1, that juror was originally an alternate, and she ended up getting on the actual final jury of 12. And I can't remember the reason for that. If I ever knew the reason for that, it escapes my memory at this point here today. Anyhow, I listened to all of those hours of jury selection, and I never zeroed in on the questioning of this juror and realizing, who it might have been. I couldn't make sense of it to find a clip of the audio to find out, what was actually said during the jury selection process. But I did hear them argue so many other, challenges. And if there's a required challenge for cause, I didn't hear it. But there were plenty. There was somebody that was going to work for the DA's office, and they excused that juror. But, this technically, and I guess it wasn't argued at the time, and that's the defense attorney's fault. So, I mean, if she was arguing in the appellate court ineffectiveness of ineffective counsel because the defense attorney didn't challenge that juror, I don't know. I don't know. And I'm not an attorney, but I promise I will ask one once I get the documents in my hand, all of them. I've seen some, but not all. So point number 2, issue number 2. The trial court erred in failing to grant Ms. Stauch's motion to suppress the search of her iPhone 8 because the warrant was overbroad and lacking in particularity as required by the Fourth Amendment. And Letecia has been complaining about them taking her iPhone 8 on January 29th of 2020 during her interview at the El Paso County Sheriff's Office. She was really pissed about the way they took that iPhone. And they didn't have a search warrant yet when they did take it. And so when I say that Letecia's been planning for this appeal since before she was arrested, that's kind of what I meant. And I'm going to go over and check comments. I have been neglecting chat, and I apologize while I play this video of Letecia's iPhone 8 being snatched against her will.
Here, let me get somebody to escort you. Okay. Hey. Hi. She said that I could go. Well, can you talk to me about what? Can I? You told me I could. I know, but I left. I understand that. So we started and I left, and I just want to get the fill in. So I have a couple questions about Sunday, if you're okay filling that in. I know you're tired.
I'm tired.
But
you said that I could go. I just want to take a break. That's all I'm asking for.
Where do you want to go?
That means I want to just go rest. Like, she said I could drive myself to the hospital, so I just don't want.
What do we need to go to the hospital for?
Am I able
okay?
to just go? I mean, what do you mean am I okay?
This is the first I'm hearing about a hospital. I mean, what's going on with that?
This is why I'm waiting, because I've already given her information that you guys can clearly watch and see, and you can know why I'm going to the hospital, because she wants to get DNA, or to have your body checked for So.
Were you sexually assaulted? When did that happen?
It happened on Monday.
On Monday? What?
I can't do this right now and go through it again. I can't.
Okay.
I can't.
So let me make sure that we've got everything lined up for a seeing exam. That's what she was talking about.
Yeah, she's gonna do that, and I'm gonna just take a break. I want to get food. Look at my lips; they're chapped. I haven't.
You want some food?
I know.
What do you want to eat?
Okay, she just said I could be escorted out.
Okay. Okay.
I promise. You have my number. I haven't not.
You're done with all this?
Right. I haven't not communicated with you. I have been.
Are you done with that coke?
Nothing but. Can I not take it?
You can if you want.
Yeah.
I just didn't know if you were done with it. We recycle them too. So.
Oh, okay. Yeah.
Okay. Hang tight for me just real quick. Let me make sure that she doesn't have any other questions, because she finished up.
She just said.
Okay. I get that. I get that. Let's just let me double check with her.
She said I could go.
But she finished up the interview.
Are you holding me here?
I'm not holding you.
Okay, so can someone walk me out?
You want to go? You want to leave?
I will. Okay. I will clearly answer your questions. I just want to take a break. I've literally followed all your.
Where do you want to go for your break?
I want to see my child. Okay. I want to get lunch with her.
Well, I'm more than happy to get you lunch, or to bring your daughter here, or whatever needs to happen. I'm not saying that you can't leave, but I would like to finish up this conversation with you. There's a couple of questions about Sunday that I have, and this is the first time that I'm hearing that you're sexually assaulted.
Are you saying that right?
That would be. Well, you came towards the door, so I opened the door. If you'd like to have the conversation in the room, we can. It's up to you. But like I said, I missed out on a bunch. So,
am I please able to just go and chill out?
Yeah, we can just sit in the drink. Where do you want to go?
So, am I not allowed to? I'm clearly asking the question.
Well, I'm trying. So, I guess our communication isn't the greatest at this point in time. Are you wanting to leave the office to go get something?
Right. Yes. I just.
Okay.
I clearly have. You have my number. I'm not.
Okay.
I'm not gonna not answer you or anything. You need to answer you.
Okay.
My name's Mitch. How are you? Good. Good. So let me talk to you. So come on in for a second.
I understand. I just want to get directions.
I get it. And so once again, we're back in the interview room.
Okay.
We're on camera. Mitch Mahalko, lieutenant with the investigation section.
Okay.
Okay. So at this point in time, what we had just discussed outside, and tell me if I'm wrong, is that you decided that you wish to leave and that there's no problem with that. I asked if
you didn't ask. You took.
Okay. So
You took.
Understood.
Okay.
So at that point in time, you relinquished the phone to me. I
didn't relinquish the phone. You took it.
Listen, I took the phone.
Okay.
And I told you that we would be applying for a search warrant.
Okay. You said applying.
That's correct.
Sir, I'm not going anywhere. I literally just need directions. I mean, I have family numbers in there I don't have.
Understood. So at this point, we're going to be applying for a search warrant. Is that understood?
Okay, I'm gonna ask you one favor. You let me find out, or you show me something that you can legally take my phone, and you don't have a search warrant yet. Can you show me that?
Understood.
Can you show me that?
No.
Can you show me that?
We're being video
I
recorded.
understand, but could you show me that, sir? Because that feels like that's kind of a little unconstitutional.
And if that's the case, that can be something that you can bring up.
No, that sounds
So at this point,
unconstitutional.
we're going to go ahead and hold on to this phone.
No, that's unconstitutional. Okay, can I use another phone if I'm an attorney? That is unconstitutional.
There are multiple phones here within the division. So if you need to
I'm not hiding anything from you. I just want directions. I want to be able to call my family.
Understood.
No, you don't understand.
I do.
No, you don't.
And this is the report.
You are doing something that's unconstitutional. You can award have it. Thank you.
So we're going to hold on to this, and we are applying for it.
But why?
So
It's not.
do you wish?
You don't even have a warrant yet. I just want
Listen.
directions. You can have the phone.
Is there somewhere that I can write directions
No,
on for you?
I want to be able to have access to call while I'm not. That's all. That's all I want is access to call. You can. It's not about the phone or the number. It's access to call.
So, Tisha, at this point,
We've got you for false reporting. At this point, you're going to be held until we can get a search warrant. We're going to have a nurse bring the examiner to the exam, make sure you do okay. And we're going to have to identify suspects, okay? So I'm going to hold you here until we get that search warrant.
Do I have to sit in this room?
Yes.
Do I have to stay at the door? I mean, I've been shut up in here, ma'am, and I've been nothing but respectful to you.
sure, and I'm.
I just, and sir, can I speak to you too? I don't care that you had the phone. You took it out of my hand, and that was very disrespectful. If you would have just asked me for it, I would have given that to you.
That was very disrespectful. So after, so she's trying to leave the room, and she gets out into the hallway, and that's where Mitch Mahalko stops her, because they don't want to let her leave, even though she's technically free to leave, right? And then she gets back in there, and then she starts, telling them how they're doing their jobs wrong. But his response was perfect. He was like, well, then that's something you can bring up. Letecia says what he's doing is unconstitutional, and he says, well, then you can bring that up. And she did. So long before trial, she brought it up. Let me see if I can share my screen. So I have the original motion to suppress the live stream. And let me make sure that worked. Yep, there we go. Okay. So on the motion to suppress the contents of her cell phone, it's a 5-page motion. So Ms. Stauch moves to suppress as incriminating evidence any and all physical evidence seized from the gold iPhone 8 on the following grounds. Number 1, the Fourth Amendment to the United States Constitution of the Colorado Constitution protects persons from unreasonable searches and seizures and prohibit the issuance of a search warrant except upon probable cause supported by oath or affirmation, particularly describing the place to be searched and objects to be seized. Number 2, the purpose of this particularity requirement is to prevent the use of general warrants authorizing wide-ranging, rummaging searches in violation of the Constitution's prescription against unreasonable searches and seizures. Let's see. Number 3, a police officer seeking the issuance of a warrant must present an affidavit containing facts sufficient to provide the magistrate with a substantial basis for determining the existence of probable cause. Number 4, the magistrate shall make the probable cause determination only with reference to the facts contained within the four corners of the affidavit and the reasonable inferences that may be drawn from those facts. Number 5, to establish probable cause, the affidavit supporting the warrant must allege facts sufficient to cause a person of reasonable caution to believe that contraband or evidence of criminal activity is located at the place to be searched. Number 6, the substance of all the definitions of probable cause is a reasonable ground for belief of guilt, and that the belief of guilt must be particularized with respect to the person to be searched or seized. Number 7, as part of this same inquiry, the affidavit must supply a sufficient nexus between criminal activity, the things to be seized, and the place to be searched. Number 8, an affidavit containing only vague allegations that the defendant engaged in illegal activity without establishing a nexus between the alleged criminal activity and place to be searched cannot establish probable cause. Number 9, failure to satisfy any of the above requirements violates the Fourth Amendment and analogous provisions under the Colorado Constitution. Number 10, the fruit of the poisonous tree doctrine excludes evidence discovered as a result of a Fourth Amendment violation. Number 11, further, when law enforcement is requesting to search digitally stored information, the court is required to impose limitations on the search. We recognize the reality that overseizing is an inherent part of the electronic search process and proceed on the assumption that, when it comes to the seizure of electronic records, this will be far more common than in the days of paper records. This calls for greater vigilance on the part of judicial officers in striking the right balance between the government's interest in law enforcement and the right of individuals to be free from unreasonable searches and seizures. Number 12, the Colorado Supreme Court has recently addressed cell phone searches and the particularity requirement of the Fourth Amendment. Given modern cell phones' immense storage capacities and ability to collect and store many distinct types of data in one place, this court has recognized that cell phones hold for many Americans the privacies of life and are therefore entitled to special protections from searches. Further, this court has held that a warrant authorizing the search of a cell phone simply for general indicia of ownership would violate the Fourth Amendment's particularity requirement. Despite these recent admonitions, the warrant at issue here contains no particularity as to the alleged victim or to the time period during which the assault allegedly occurred. Rather, it permitted the officers to search all texts, videos, pictures, contact lists, phone records, and any data that showed ownership or possession. We conclude that such broad authorization violates the particularity demanded by the Fourth Amendment. Because it authorized a general search of Koch's phone, which I guess is just, anyway, it was also unreasonable under the Fourth Amendment. And that's from the People v. Koch, so that's why they were searching Koch's phone. Anyway, the warrant in question here is even more broad than the warrant in Koch. The warrant allowed a search of everything in the phone without even a connection to time and date. If there was any doubt regarding the scope of the warrant, Paragraph M allows the search of any and all data stored within any computer storage device or other processing and/or storage devices. The search warrant not only allowed the unbridled search of the Apple iPhone 8, but to search any cell phones or other electronic devices found. Further, the way Apple iPhone 8 was searched was in essence a general search. Rather than particular items being sought and copied, the entire contents of the cell phone were seized, copied, and stored. The defendant requests an order suppressing the above referenced evidence and statements and all evidence which is a direct or indirect fruit of the above described evidence and statements, all pursuant to the 4th, 5th, 6th, and 14th Amendments to the United States Constitution. Yikes. Okay, and then if I move to the next tab, what I have here is, let me make sure I'm sharing it. Okay, there we go. So this is the actual, there are 13 pages. So let's just go through it. So request for sealing of search warrant. No big deal. These are just attachments to that motion. Order to seal the search warrant. So here's the search warrant itself. Whereas Detective Marissa Williams has made an application and affidavit to the court for the issuance of a search warrant, and whereas the application is in proper form and probable cause is found for the issuance of a search warrant to search the person and or premises specified in the application. Therefore, the applicant and any other peace officer into whose hands this search warrant shall come is hereby ordered, with the necessary and proper assistance, to enter and search within the next 14 days the person, premises, location, and any appurtenances thereto, description of which is a gold Apple iPhone 8 and a black Mark New York purse belonging to Letecia Stauch, currently held at the El Paso County Sheriff's Office. The following person, property, or things will be searched for and, if found, seized. And so the ones that they have marked are is or has been used as a means of committing a criminal offense. Okay, so they're saying that she used her phone in a means of committing the offense. And the other one is would be material evidence in a subsequent criminal prosecution or required, authorized, or permitted by a statute of the state of Colorado. Okay, we think she used it in a crime and it would be material evidence, but they're saying that's way too broad. And I mean, it is very broad. So this search warrant, so ordered this 29th day of January 2020, which is the day of Letecia Stauch's police interview. And this was at 9:49 p.m. We're only on page 4. Let's see what else is in here. Application and affidavit for search warrant. It looks the same to me. Okay, that looks the same to me. Attachment A. Is this new? Yes. Okay, so it's an attachment to... So maybe they'll get more specific here. I don't know. Your affiant, Detective Marissa Williams, hereafter referred to as I, a deputy sheriff for the El Paso County Sheriff's Office, currently assigned to the Investigations Division, state under oath that I have personal knowledge of the following facts. The facts set forth within this affidavit are based upon information your affiant has gained from this investigation, your affiant's personal observations, your affiant's training and experience, and or information related to your affiant by other law enforcement officers. Since this affidavit is being submitted for the limited purpose of securing a search warrant, your affiant has not included each and every fact known to him concerning this investigation, but has set forth only the facts that are necessary to establish probable cause to believe that a crime has occurred. All information contained in this affidavit can be found documented under El Paso County Sheriff's Office, Case Report 20-1382. On Monday, January 27th, 2020, at approximately 18:55 hours, El Paso County Sheriff's Deputy Sean Donahoe responded to the address of 66 Mandan Drive. We've been through all of this. Missing person. I mean, this isn't the affidavit of probable cause for her arrest. This is just an affidavit in support of the search warrant. Showing, and this is going into detail, she has been communicating with her 17-year-old daughter, Harley, via text message and Facebook application continuously. So it does go over details of how she used her phone. She left her phone at home during the crime. Let me see here. And I'll put this document on the website so you can read the whole thing if you want. I'll just make it easy access. I just don't want to get into all of the details of the case for our purposes here tonight. I just want to talk about that stupid cell phone. Okay, in furtherance of this case, your affiant submits that it is necessary and reasonable to search the phone and the purse belonging to Letecia in order to ascertain past location and communication, as it will aid in the location of the missing child, Gannon. Additionally, identification of any handwritten notes and any financial accounts potentially used will aid in identifying information Letecia did not provide to law enforcement about events that did or did not occur, as well as financial accounts she has access to, which may have been used during the time Letecia has not accounted for between Sunday night and Wednesday afternoon. Based on the Colorado revised statutes, false reporting to authorities, if a person knowingly makes a report to law enforcement of a crime or incident within law enforcement's official concern, such as a runaway child, a kidnapping, or a sexual assault, he or she knows did not occur, he or she commits such offense. Based on the facts and circumstances described here, Letecia made a false report to law enforcement regarding Gannon running away from the residence at 1500 hours on Monday, because on Wednesday around 1200 hours, Letecia changed her statement and told law enforcement he had been abducted by an unknown person who sexually assaulted her. And that really wraps it up. So going back to that video that we just watched, where Mitch Mahalko comes into the room. Well, actually, while he's out in the hallway, you hear Jessica Bethel say, okay, well, here's where we're at. And Mitch Mahalko says, we've got you for false reporting. You're being detained. And you're being detained until we can get a search warrant. And they were going for several search warrants. One of the search warrants that they ended up getting was in order to force Letecia to have a SANE exam at the hospital that they wanted to transport, but she wanted to go so desperately, and they had already taken her phone, and, we know where it all goes from there. I won't get into all of that. I'll try to stay focused on the points of, let's go back to it here. There we go. So again, now these were the original motions to throw the iPhone 8 out of evidence before trial, and the judge denied that, and the iPhone 8 stayed in and made it to trial. And, whether they should have been able to just make a copy of everything that's on there with no regard to date or time or specifically what they were looking for. I mean, probably not, but I'm not a judge. And, Judge Werner was nothing if not thorough and careful with this case. It obviously meant a lot to him. Anybody who watched the trial would know how much it meant to Judge Werner. Anyway, so that's issue number 2, is she's still complaining about that cell phone, which, yeah, they took it before they had a search warrant to go through it. But come on, you really think they're going to reverse her conviction over that? Or, the juror, having a son-in-law that worked for the DA's office. Now, I mean, if it were up to me, I wouldn't have allowed a juror who has a son-in-law that works for the DA's office. But again, I wasn't there. And I'd like to go back to, that here in a minute, because I do have a couple of questions that I believe have been answered in the press. So I'll check. Anyway, moving on to point number 3, the trial court erred in allowing testimony about the defendant's prior quote unquote manipulative behavior. Now, I have no idea why the person writing this would put quotation marks around manipulative behavior, because Letecia Stauch is the perfect example of manipulative behavior in every way. I don't know why we need the quotes. The defendant has a ton of previous manipulative behavior, and there are examples of her manipulative behavior going back decades. And there's so much proof that there's no one she won't throw under the bus to get her way, or to prove that she's not lying when she definitely is. How can you try so now they're arguing that is, I guess, some sort of like 404B evidence, like prior, bad character evidence. And I can't, now that one I haven't seen that issue at all. As far as the new court documents go, I haven't seen that one. I can't wait to see, what examples that they use that were somehow egregious. I don't believe that Letecia Stauch was convicted because the district attorney's office proved that she was manipulative as hell. She wasn't convicted of being manipulative. And there are many manipulative, predatory people on this planet that don't kill innocent children who are in their care and custody. But if they have to prove that she's sane, they have to prove that she's calculated. Not only is she not out of her mind, it may be crazy, it may be chaotic, it may be all at once and all over the place, but she absolutely is present mentally. She knows what she's doing even when she doesn't know what she's doing. She is the spinner of plates. Always. But she's always doing it on purpose. She's never out of her mind when she's doing it. And so anyway, I'm really looking forward to seeing that one. Let me go back over here and check on you guys in the comments. I'm going to take this down for a second. Okay. I appreciate you guys participating in the discussion. If I was just looking at this by myself, I would end up in another rabbit hole, and who knows how long it would take me to get out of this one. And Anti-Empire says, notice how none of the reasons for her appeal have anything to do with her being guilty. Yeah, she admitted that she did it, kind of. The only time that I've seen she admitted to Gannon's murder was when she was lying to Dorothy Lewis and pretending to be Maria, who was the protector. And Maria, the protector, mistook Gannon for someone else. And that's how she explained the gunshot. He was standing on the bed, and Maria allegedly shot Gannon, and that's how he had the upward trajectory through the jaw. And into a pillow, by the way. Did he have a pillow behind his head while he was... anyway. I'm sorry, guys. She still makes me as sick as she ever has. As far as I know, that's the only time that she has admitted to killing Gannon. But her offense was an affirmative defense, and that counts. Without the iPhone 8, would the jury have found her guilty still? Her only not guilty was not an option. That wasn't even on the table at her trial. The two options were guilty or not guilty by reason of insanity, at which point she would be sentenced to a mental institution on a civil commitment. I can't imagine any of these three. I can't imagine a world where any of these three complaints would justify giving that monster another trial. And that family that she continues to put through hell would have to deal with that? No, absolutely not. No. No. Let's see. Truly, thank you for sharing this because I haven't been able to listen to anything about her in such a long time. It just shatters me. I saw this and thought your channel would be good. I'm glad. I'm glad that you're here. And it has been a while. But I'm working on some other projects, and it's, this is something new. And I will go live again. Actually, I probably won't go live. What I'll do is I'll record all of the documents, but I would like to wait until after she falls on her face with this appeal. I mean, give me a break. No way. No way will she get another trial. So as soon as they shut her down, which they're going to do in writing, they've this panel of 3 judges has now, they have been presented with all of the briefs from both sides. On one side is an appellate attorney on behalf of Letecia Stauch. On the other side is the senior assistant attorney general. And so these 3 judges, the appellate judges, have seen all of these briefs that have been filed and all of this information about what she's complaining about and how it was truly handled. And once that's done, then this panel of judges will release a document with their ruling. And the same thing happened in Patrick Frazie's last appeal. And also, I need to look into Patrick Frazie's current appeal. Patrick Frazie is appealing his case yet again. And he would have a better shot than Letecia, and he doesn't have a shot at all. So, anyway, as soon as they file that and I'm able to access all of the things that they have currently sealed, then I will make a video where we go over every piece of what she tried. I mean, we know a lot about what she's been trying to claim, reasons for her appeal and reasons she was wronged and reasons that she's a victim. And in a lot of ways, I hate that I'm live here tonight talking about this bitch. It's frustrating. But these are the only 2, current event videos that I'm planning. I wanted to talk about her appeal, the ridiculousness of it all, and to show you that these are the 3 points that she came up with after 3 years of scheming in her prison cells. This is what she came up with. Anyway, so I wanted to discuss the appeal tonight, and then the next step is for the appellate court to shoot her down in writing, and for me to gather all those documents and read them all front to back, probably with no commentary because, I tend to ramble, which I'm doing right now. So I am going to probably wrap this up for this evening. Before I do that, I do want to read the Fox 31 article. But before I do that, I just want to play that news clip again about her stupid appeal.
The Colorado Springs stepmother convicted and sentenced to life without parole for killing her stepson Gannon is appealing her conviction.
Letecia Stauch's case went before 3 judges today. Fox 31's Nicole Fierro's on it.
11-year-old Gannon Stauch disappeared exactly 6 years ago today. A jury convicted his stepmom, Letecia Stauch, 3 years later in May of 2023, and a judge sentenced her to life without the possibility of parole. Today, an attorney representing Letecia Stauch in the Colorado Court of Appeals used his 15 minutes on the courtroom floor to argue the first of these 3, quote, issues they submitted as reasons why Stauch's conviction should be reversed. They say a juror connected to her trial had a son-in-law who worked for District Attorney Michael Allen's office. Allen was the lead prosecutor in this case. They argue Stauch's team challenged the juror's family ties during jury selection, but the judge didn't get rid of the juror, and they believe that was wrong. The senior assistant attorney general told the court she doesn't think the trial judge even made an official ruling on the challenge, and she argued Stauch's team didn't follow up properly if they had a concern about this relationship during the jury selection process. The Court of Appeals judges will review a series of past Colorado cases that shape the current laws.
We reached out to the district attorney's office over her trial for comment. They sent us a statement, and we have that on our website. Reporting live here in Denver, Nicole Fierro, Fox 31.
Okay, so I want to read the Fox 31 article. I did look at that statement from the DA's office, and you're welcome to do that. Their website, I think it's just kdvr.com. It'll be easy to find. But basically, all the district attorney's office said was that they stand behind their case, which, obviously, my God, why wouldn't they? She's just too much. Okay, so let me see if I can add this. Here we go. Okay, oral arguments in an appeal for Letecia Stauch, the El Paso County stepmother convicted of killing her stepson Gannon, unfolded before 3 judges Tuesday morning. Letecia was not present in person at the Colorado Court of Appeals. Eric Samler, an attorney representing her, argued that her case should be reversed because of a juror on her trial and who that juror was related to. In the 15 minutes allotted to each side for oral arguments on Tuesday, Samler told the appeals judges that a juror connected to Letecia's trial had a son-in-law who worked for District Attorney Michael Allen's office. Allen was the lead prosecutor in the case. Samler argued that Letecia's defense team challenged the juror's family ties during the jury selection process. Despite the challenge, Samler told the appeals court that the trial judge did not get rid of the juror. In a court briefing, Samler argued, quote, "This is structural error requiring reversal of the convictions," end quote. Senior Assistant Attorney General Catherine Gillespie told the court that she does not think the trial judge even made an official ruling on the challenge. She also argued that Letecia didn't properly challenge the juror under a specific subsection of the law. Because Letecia didn't challenge the juror under 1B, she didn't address whether MB are the juror's initials. Let me start over. Because the defendant, Letecia, didn't challenge MB, the juror, under 1B, she didn't address whether MB's son-in-law met the family within the 3rd degree requirement, and she didn't correct the court's misunderstanding as to her challenge. The trial court wasn't on notice that this question needed to be resolved. Gillespie stated in a brief filed in the Court of Appeals ahead of Tuesday's oral arguments. Criminal defense attorney and Fox 31 legal expert Christopher Decker put these arguments into perspective. "This is not a surprise," Decker said. "This is not some crazy cooked-up scheme to unwind an otherwise valid conviction. This is the process that we have. It's an important process because there are times when convictions result because mistakes have been made, because an improper juror has been selected." Decker explains that in this process, the Court of Appeals judges review a series of past Colorado cases that helped shape the current laws. Decker said, so one would need to go through all of the existing case law, apply that to the facts of this particular case, and those are disputed, to determine whether or not this particular juror in this particular situation was improperly impaneled, Decker said. And if the existing law does not resolve the question at hand, they will consider making their findings, essentially making new law. Fox 31 reached out to the 4th Judicial District Attorney's Office and received the following statement. And this is their exact statement, the one that's on the website. Appeals are a natural part of the trial process, and we are waiting to hear this court's ruling. We stand by the meaningful work our trial team put into this case and the justice achieved by the defendant's conviction and sentencing. The appeals judges ended the hearing on Tuesday, stating that an opinion will be issued in due course. So, in due course means that we do not have an ETA, but I'm sure that we will have their ruling soon enough, and I am equally sure that it will be rejected. That doesn't mean that she's not going to file another one if she can maneuver herself into a position of being able to bend the rules enough to get another one. She wasn't technically within the filing requirements of this one, but she threw enough of a fit and came up with enough, fake ass extenuating circumstances that she was able to go ahead and file this appeal. And we're here now, giving that monster attention 6 years after she did what she did. And I hate it. I also think that it's important that we talk about what she is continuing to do, and we do it in such a way that is respectful to every single person that Letecia Stauch has pulled into this years-long nightmare, which is what it is. And when I say that, of course I mean Gannon's siblings and Gannon's parents and Gannon's family and friends and his neighbors and every person that little boy has touched, in his life, which was taken far too soon by a monster living under his roof and in charge of his well-being. I hate it. So I guess as I sign off here, I hope that what I've presented here tonight was valuable. Like I said, the only other video I'm going to do on the topic is a full reading of the court documents with no commentary. Aside from that, I've got a 2-part docuseries that I'm working on in collaboration with others. And we'll get into that more later. It's not important now. But what's important now is that Letecia be shut down. She just doesn't deserve a voice at this point, still trying to pretend that she has somehow been wronged. It makes me sick, and I hope that she does not sleep well tonight. And I'm sorry to sort of end this on such a negative vibe, but I am going to go ahead and end the stream. And I'm sure that I will see you guys again when we have the rejection and all of the new court documents. I hope that you guys have a good night. If you haven't already, take a look at the live stream that we did a couple of hours ago about Nicole Fierro's involvement in the case. Let me just check the comments before we go. And Jilly Bean says, Jennifer, I feel, knows about as much about this case as DA Michael Allen does. And I definitely do not. I know that is meant as a compliment, and I take it as such. And I love you. I still, even after all these years, and the book, which is fully written and just not published yet, even after all of these years, I still have so many fucking questions. Let's see. Okay, well, I am, like I said, I'm going to go ahead and end it. But I have been, for anybody who hasn't been back here for quite some time, I have been going live every Saturday night at 6 p.m. We do a post-trial study group, Mountain Time, 6 p.m. Mountain. And then at 8 p.m., we do a public live stream. I just went ahead and did both of those public tonight because they really, I felt, went together. So I hope to see you guys again soon. Thank you for coming back if you're coming back. Thank you for showing up if you're just now getting here. I will see you guys next week or maybe even before. Good night.